We will go into details on the Republic of Korea case, and I'm pleased to welcome our two speakers. The first one is Cheon-min Choi and the colleague Young-soo Lee. They are members of World Without War, based in Seoul, and they will be speaking more about their campaigning for CO in Korea. World Without War was founded in 2003 as a network of pacifists and anti-militarists in Korea and has been campaigning for peace since then. Conscientious objection has been a particular focus in their campaigns, and their work was very important in setting the right to conscientious objection be recognized in Korea in 2018, which has been a result of a long and resilient campaigning. So I'm pleased to give the floor to them, and thank you for being here with us.
Okay, thank you, Jaira. And I shared my PPT. Just a moment. Okay. Greetings, everyone. I'm Yong-seok Lee from the World Without War. Thank you for the opportunity to talk about the Korean conscientious objection movement, especially strategic litigation, in this webinar. While preparing for this presentation, I was able to review the strategy of the Korean CO movement once again. The World Without War has tried to achieve the right to CO in various ways. We have targeted both the legislative and executive judiciary to be recognized for CO rights. Sorry. Among them, the judiciary was the most responsive, and consequently, the role of the judiciary took precedence over the legislative and executive in the legal recognition of the right to CO in Korea. I can only speculate why the judiciary was more favorable to the CO than legislative and executive. I think the main reason is that the judiciary could be less concerned with the public opinion than the legislatures and the executive, which are prone to be shaken by public opinion against the conscientious objection. Several of the male human rights lawyers say they start the CO campaign out of regret for ever witnesses CO who were punished when they were serving as a military judicial officers. Male judges who judge conscientious objectors have also experienced punishing COs in the past as military justices. Like human rights lawyers, some of them may have felt sorry for punishing COs in the past. I'm guessing that feeling had an effect on the not guilty verdict. The strategic litigation in Korea can be divided into two main categories. First, it's a domestic procedure. The domestic process is divided into the following three parts: litigation procedure, constitutional appeal, National Human Rights Commission. The first thing World Without War prepared was the proceedings. This was possible because there was a group of human rights lawyers, Minbyun, in Korea. Until the 1990s, CEOs were tried in a military court, sentenced to 3 years in prison, and imprisoned in military prisons. As civil rights lawyers began giving free arguments on behalf of Airbus witness CEOs to the court. CEOs were tried in private court, and the sentence was also reduced to 1 year and 6 months. The lawsuit claimed innocence. Ultimately, the goal was to receive recognition of the CEO, as well as to improve the treatment of CEO in prison through lawsuit with the help of human rights lawyers. Continuing trials and going to jail was effective in publicizing the issue to Koreans. CEOs organized the supporters to go to listen to CEO's trial, and when convicted and arrested, they made comments or informed the media to publish articles. In Korea, the Constitutional Court has the legal final interpretation authority. Unless the National Assembly made a law, the Constitutional Court decision was necessary in order for the right to CEO. In total, 3 constitutional petitions were made, but in 2004 and 2011, they were not recognized. Finally, in 2018, the right to CEO was recognized. When making a constitutional petition, World Without War considered the propensity of the constitutional judges. In 2011, the composition of the constitutional judges were not good, so World Without War didn't have much expectations. The National Human Rights Commission of Korea was established in 2001 with the demand of human rights movement. So many human rights activities had high expectation for the launch of the National Human Rights Commission. The CEO movement tried to be registered as a first appeal with the National Human Rights Commission, but it became the second because there was more diligent groups. In particular, we actively used the National Human Rights Commission to rectify the discrimination and human rights violation that prisoners suffered in prison. It proposed recommendations such as freedom of religious assembly in prison, vegetarian rights for inmates, and access to books. Since the National Human Rights Commission of Korea's recommendation were not binding, they were not immediately reflected in many cases. But since the National Human Rights Commission of Korea was recognized as a state agency with credibility, news of their support helped improve the perception of society as a whole. In Korea, strategic litigation was an effective method because institutions as a court, Constitutional Court, and National Human Rights Commission of Korea have authority that is more widely recognized compared to other government ministries. Accumulating judgment or decision, acknowledging the rights of CEOs, and accumulating the number of innocent convictions in royal court ultimately played an important role in eliciting legal recognition of the right to CEO. Second, utilizing the UN system. This contents overlap with Rachel's presentation, so I will keep it short. The Korean CEO movement actively utilized the UN system from the beginning. The resolution of the Committee on the Convention of Freedom, the resolution of the Human Rights Committee, and the Human Rights Council's National Human Rights Review, UPR, were all utilized. We got a lot of help from Rachel, and a cautious objector's guide to UN human rights system was also of great help. World Without War made CEOs aware of the implication of using UN procedure and gathering CEOs to file a complaint with the Committee on the Convention of Freedom. In addition, we prepared to submit a written opinion from the Korean civil society and submit a report that refuted the Korean government report on the recommendation of UN mechanism. The recommendation and decisions of UN mechanism vary from government to government, but they have been useful in pressing the government. The UN's recommendations and decisions have also had a great influence on actors in frontline courts. The judges cited international legal ground and recommendations from the UN as the main reason for acknowledging innocence in the judgment. Thank you very much.